Hello friends, how are you? Today we are going to discuss an important perspective wherein I will discuss whether the accused person who has been convicted under the Prevention of Corruption Act could be terminated from his services without having opportunity of being heard. Number 2, is it not necessary to serve a show cause notice to him while passing the impugn order of the termination? These are 2 points which I will say the chilling point which will definitely constitute the agenda of the present discussion. Friends, recently Gujarat High Court in its verdict clarified that if the order of termination is passed, even though the accused is convicted under the Prevention of Corruption Act without giving him any opportunity of being heard and even without issuing the show cause notice, the said procedure and proceeding is illegal and the order of termination passed in consequence of it definitely would come within the purview of abuse of law and it is liable to be set aside. Friend, in the said judgment, the case of the prosecution was that a successful trial proceeding was conducted concerning the accused person under the Prevention of Corruption Act, in which at the prima facie level it was found that the accused had demanded and accepted the bribe amount and ultimately he was arrested and finally he was bailed out in consequence of the order of the competent court. Subsequent to this, charge sheet was filed and charges were framed. In the meanwhile, the opportunity of being heard was given to him by the way of trial proceeding. In the trial proceeding, the prosecution has put up its case by the virtue of ocular and documentary evidence and inter alia succeeded to prove its case beyond reasonable doubt. When the accused was convicted, the order of conviction was communicated to the department and department, while acting in consequence of the rule governing the services of the accused, had terminated him, although no opportunity of being heard was given to him, although no show cause notice was issued prior to such proceeding, but the same would not made the proceeding illegal and abuse of process of law. But the said proceeding was challenged by the accused before the concerned High Court by the way of writ jurisdiction. The primary attack of the accused was that although the opportunity of being heard, although no show cause notice was not issued to me by the prosecution, and as per prosecution the entire proceedings adopted by them is legal, but in real sense and in the light of modern development of the legal position, the said approach is illegal. Although the prosecution even before the High Court retrieved the previous view taken by various High Court including the Apex Court, but they have totally forgotten to consider the recent law considered by the Apex Court and various High Court concerning the issue of service matter of the concerned accused, wherein it was clearly held that if you want to pass the order of termination even though the accused is convicted under the Prevention of Corruption Act, you have to give him the opportunity of being heard along with the opportunity to have the show cause notice. Friends, I am going to retrieve what the Honorable Gujarat High Court exactly stated or cited in its judgment. For this, I am referring para number 6 of the judgment. In view of the aforesaid decision in Sunil Kumar and the ratio thereof, and the decisions of this court in H.N. Rao, and those judgment taking the view that prior notice is not necessary, no more stand to be good law. Means the prior notice is necessary before proceeding further, specifically when you are going to terminate the accused on the ground that he is convicted under the Prevention of Corruption Act. And finally, what the court held? The court held, in the view of the above discussion and the reasons, the impugn order of termination of services of the petitioner are quashed and set aside, and the petitioner shall be entitled to be reinstated in the services on his original post with all consequential benefit and back wages. The reinstatement of the petitioner shall be granted within 15 days from date of receipt of this order, and the petitioner shall be paid the consequential benefits including the back wages arising to be paid by the virtue of this order within 4 weeks from the date of his reinstatement. In the view of the discussion above, the petition is allowed and the order of termination dated so and so is quashed and set aside, and the petitioner shall be reinstated in services on his original post with all consequential benefits, the reinstatement shall be granted within a period of 4 weeks from the date of receipt of copy of this order, and the consequential benefits to be paid within the time so specified. So, friends, it is quite clear that even though we are convicted under the Prevention of Corruption Act, but before passing the order of termination, the concerned authority are bound to hear you and they are bound to issue you the show cause notice, because in the present case at hand, after the conviction, the accused has challenged the same before the Court of Appeal and he had taken the stay on the sentence, and that's why he sustained that even though I was convicted, but the order of conviction and sentence was not in force, they had been stayed in consequence of the order of the concerned competent appellant court. So this is a very good point, and if this point is applied in our case, then definitely we could have a success in matter of termination, specifically when we are convicted under the Prevention of Corruption Act. So don't worry, apply this law, and this law would be helpful to get rid of from this problem. So have a nice day. See you soon. Jai Hind, Jai Bharat.